Lone Star Ag Credit, they're our constant Ranching 101 sponsor. Even throughout this crisis, they've still been our sponsor for this. So unfortunately, you don't get the cookies that you get in the office, but you still get the benefit of having this class thanks to them. So that is kind of it in a nutshell. I do want to go ahead and do a short introduction for Jackie. Jackie's a member of Lincoln Financial Advisors, Agribusiness Services, a select group of advisors that specialize in assisting ranchers, farmers, and large landowners in the areas of estate, succession, and financial independence planning. She employs a client-centric approach to addressing the issues families face today. Jackie's strength is creating objective and customized plans that help her clients with an enhanced sense of security regarding their future, as well as the future of their family and operation. Jackie is a member of TSURA and NCBA. She's a past president and current vice president of education and beef promotion for the Texas Coastal Cattlewomen. In addition, she is on the board of 22 Lemons Farm, a 501c3 in Galveston, whose mission is to teach agriculture to children with hands-on learning in an outdoor classroom. Jackie has been in the financial services industry for 19 years, spending her entire career with Lincoln Financial. So with that, I will go ahead and turn it over to Jackie for her presentation. Like I said, just keep any questions that you have, just send those through the Q&A or the chat box, and we will get to those at the end. Thank you all so much.
Thank you, Gabby. Good afternoon, everyone. And I hope everyone's doing well and getting used to the new normal. I got to say, when the year started, I don't think we ever thought we'd be here come August with a pandemic. We also have unprecedented stimulus coming into the economy and an election. So it's been quite a year. I don't know if you're ready, but I'm ready for 2021. Today, we're going to just cover a high-level overview of estate planning, and then what we'll get to is questions. We had several great questions submitted previously, and I can see that some are coming into the Q&A now. As Gabby said, I am with Agribusiness Services. So we work with ranchers, farmers, landowners, typically large landowners, and we focus on this because there's just a different set of, I guess you would call it, challenges that landowners face. Usually, typically, that is that land is their largest asset, and it's a large illiquid asset. So we have 28 advisors that are in the agribusiness. We're spread out all across the country. And so that's who we are. If you want to learn more, you can go to Lincoln's Agribusiness website. So let's just start with, what is estate planning? Estate planning is a process of accumulation, management, conservation, and transfer of wealth. You know, many people have contemplated the inevitability of death and taxes, and Benjamin Franklin is famous for saying, in the world, nothing is certain but death and taxes. And look at estate planning as preparation for both of those things. But like snowflakes, no two families are the same. So no estate plan is going to look the same. No two families have the same issues, the same structure. So when we're talking about some of these tools like trust, some families they're going to work great for, some families they're not. But your plan has to take into consideration your particular assets, your debts, your family members, and your wishes for your estate. So let's start with the basics. Basic estate documents. These are the documents we typically call an ancillary package that we feel every person should have. First is going to be a will. The next is a financial power of attorney, a medical power of attorney, a living will, a HIPAA release, and a disposition of remains. You know, there's a misconception about who needs estate planning, that it's only the ultra wealthy that need estate planning. I say everyone needs a plan. The plan needs to tell your heirs, your assets are going to who you want, when you want, how you want. And a properly crafted plan can often eliminate or reduce estate taxes. So these are the basic documents. If you don't have these, I would say get with an attorney and get these documents put in place. So let's talk about them. Your last will is a document that gives you the control to control distribution of your assets at death. So there's two types of wills that are valid in the state of Texas. One is a statutory will. This is one that's drawn up by an attorney in an attorney's office. They'll have witnesses there, a witness that is unrelated to the person drafting the will or is not a beneficiary under the will. And then there's a holographic will, and that is one that you write yourself. It doesn't have to be witnessed, but it does have to be signed and dated. So those are two of the types of wills that are valid in the state of Texas. If you die without a will, it's called dying intestate. Intestate means that the state is going to choose where your assets go and how they will be distributed. It is another misconception that will always be your spouse. There are some states that if you die intestate without a will, some of your assets go to your spouse and some of them go to your children. So your spouse may or may not get everything that you intended for he or she to get. So let's discuss the features of a will. First is going to come your specific bequest. These are typically things like your gun or fishing equipment, cash gifts. When settling an estate, those are the requests that are going to be filled first. Next, your will is going to name your executor. This is the person that's going to handle the distribution of all the property that passes via the will. Not all property passes under your will. Things like life insurance, annuities, and IRA accounts pass via contract or beneficiary designations. So those are not going to be through the will. Also, some types of property that are held in trust will also bypass the will and instead will pass via the terms of the trust. So when we're advising clients about who to name as the executor, I want to make it clear that we do not always we always say kind of give this some thought. This is somebody who's going to need to be organized. This is somebody that's going to be need to handle all of the debts of the estate. So, you know, my grandmother named her oldest child simply because she was the oldest child. She was not the most qualified person to be executor, however. So when you're naming your executor, make sure you think about, are they capable of handling the business of your estate? They need to be organized. They need to also be willing to carry out your wishes, whether those are how they feel that the assets should be distributed or not. So I would talk to your executor and make sure they understand what your plan is. We also do not recommend naming co-executors. Death does funny things to people. I'm sure there are hundreds of stories out there of families that got along and then someone passed away and all of a sudden the family is fighting. Naming co-executors often leads to that type of in-family fighting. So I think that it's best to name someone, one, who's qualified, and two, who will carry out your wishes. The next thing that you see in a will are what's called testamentary trust. A testamentary trust does not exist until the person dies. It is just a provision in a will until you actually fund that trust. And two of the most common types of testamentary trust are a bypass trust, which is used to pass the exemption amount, the estate tax exemption amount via tax-free, and then marital deduction trust. So those are sometimes referred to as QTIPs. It's a qualified terminable interest property trust. So those are the two most common. So remember, if you want to pass assets in trust, you can do that via a trust during your lifetime or a testamentary trust. And we're going to talk a little bit more about trust in a minute. The other common clause is a no contest clause. This is often included to discourage any heirs that are disappointed in the provisions of the will from contesting your wishes. A typical no contest clause will say that if anyone goes to court and they question the validity of this, then they no longer get the property that they would have gotten under the will. Those are common clauses to prevent, again, fighting. Another provision is a spendthrift provision. This is often included to protect assets from creditors. This simply states principal and income cannot be subject to the claims of creditors. And then a guardianship clause. This is for those of you who have minor children and want to name who will take care of your child in the event both parents pass away. Without a guardianship clause, the court decides who will raise your children. So if you have two grandparents who are probably going to want to step in, they're both going to want to raise the children, here's where you can decide which of, who's going to be that primary guardian. So before we move on, I want to say that a will is not a once and done type of document. If you haven't had your will reviewed within the past 3 to 5 years, I think you should have it reviewed. Just make sure it's up to date with tax law, and as well that it still reflects your wishes. If you don't know how your will works, then I also suggest you have someone review it with you and provide you with a summary of the provisions that are in your will, who is named as executor, who is named as trustees, so that it still matches what you want. So other documents, financial power of attorney. Financial power of attorney gives someone to act on your behalf. This usually includes property transactions such as stock or bond, banking transactions, insurance, or tax matters. So I'm going to give you an example of why and how a power of attorney should be in place. We had a client that was in a terrible motorcycle accident. He was in a medically induced coma for weeks while his body healed. During this time, his wife needed funds out of his account. The account was an IRA and it was in his name, and she needed those to pay bills. Because he provided us with a power of attorney, she had access to the funds. Without that document, she would not have needed the money she needed during a time that was already stressful for her. A power of attorney ends at death. That is when the executor takes over. So if you have power of attorney over your spouse, a parent, and they pass away, you no longer have that power of attorney. That is when the other executors and trustees take over. Similar to a financial power of attorney is a medical power of attorney. This gives someone to act on your behalf in the event that you are incapable of doing it. Now, this typically includes medical decisions, disclosure of your medical records, blood transfusions, cardiac resuscitation, and organ transplant. What the medical power of attorney does not include is the end of life-saving treatment, okay? That is going to come into a living will. It's also called an advance directive. Now this says, do I want to be on life support under specific circumstances? Life-sustaining treatments includes resuscitation, ventilation, nutritional assistance such as a feeding tube, or kidney dialysis. So the purpose of this is to preserve your dignity and let you die on your own terms. I can tell you that during this virus, it has become more important than ever that we all review that we have these documents in place. We never know what is going to happen, and without these, you lose the ability to decide how you're going to be treated. This also, it avoids your family having to petition the court to end your life support. I think everybody remembers the Terri Schiavo case in 1990. She had a heart attack but was successfully resuscitated, but had severe brain damage. Her husband said she would not have wanted to remain in a vegetative state and asked doctors to remove her feeding tube. Her parents disputed that and legally challenged his decision. It took 7 years before her feeding tube was removed because it had to make its way through the court. This is the document you want in place to carry out your wishes in the event that you cannot do them. In addition to a medical power of attorney and a living will, many people have a document called a do not resuscitate, or DNR. It's critical to understand that the DNR only applies to CPR, not any other medical treatments. I can tell you that my grandmother died in July 2 years ago, and we had a family member taking care of her who called 911 when she was unresponsive, and the firemen came and were resuscitating her, had a tube down her throat until we could produce the DNR and show it to them. So if you call 911, their job is to do whatever it takes to get you back. With the DNR, we were allowed to say she does not want to be resuscitated. She was 96 at the time, so she was ready to go. Disposition of remains says who is responsible for disposing of your remains. This is also where you say how you want your remains disposed of. Do you want to be buried? Do you want to be cremated? If you have a prepaid funeral plan that includes cremation and gives instructions, this may not be as important of a document, but the last thing you need is your family fighting over whether to bury you or cremate you. So make your wishes known. So we're going to move along to trust. There are different types of trust. Testamentary, which we discussed, is created under the will. A revocable living trust, which is a separate trust document. We typically use revocable living trusts for clients that have property in several states. If I own property in Texas and I own property in New Mexico, for example, and both properties are in my name, then I pass away, my family will have to do what's called ancillary probate in New Mexico, which is two probate, one in the state that you live in and one in the state where you hold property. That can be avoided by putting the property that's out of your home state into a revocable living trust. Then it passes via trust and avoids that ancillary probate. Another thing we often encounter is irrevocable life insurance trust. And we did have a question about this, whether a trust should be the beneficiary of a life insurance policy. So if the life insurance policy is owned by, let's say, a husband and his spouse is the beneficiary, it still passes tax-free to the spouse. However, what it does is it opens up that policy to estate taxes. So the value of the policy is then included in the estate for valuation purposes for estate tax. If it is owned by an irrevocable life insurance trust, it now is excluded from the calculation of the estate. It still passes tax-free, but it removes it from the taxable estate. So if you, and a lot of people feel right now that, well, I don't have an estate tax. I still think that putting it into the trust allows you to build the provisions of how you want them to be used. And that's what we're going to talk about now, are trust provisions. Income. So a trust can state that all income be distributed on an annual basis. It can state that there is some income that it's discretionary. We typically like to see the flexibility of discretionary income. Why? Because you don't want to force taxable income to someone who doesn't need it. The only time that a income from a trust is part of the unlimited marital deduction is if it's a marital trust. So if there's a mandatory income provision in a family trust, any unspent income is included in the taxable estate. If it's discretionary, then we determine whether or not they need the funds. The other thing that the trust is going to determine is whether or not principal can be used in addition to income. An independent trustee can provide principal distributions either for any purpose, or a lot of trusts say that the only distributions that can be made are for the health, education, welfare, and maintenance of the beneficiary of the trust. A power of appointment is given to the beneficiary of the trust to decide who's going to receive trust assets. So a general power gives the power holder the right to give any of the trust assets to themselves, their estate, their creditors of either one, or anyone they choose. However, if you are holding a general power of attorney and the the person passes away while you're holding that power of attorney over the assets, it will be included in your estate. A limited power appointment gives you the power holder the right to give property to anyone but themselves, their estate, or the creditors of either. So you want to be, what we do see a lot, another question we got is this person felt like they'd set up a trust but hadn't put anything into it yet. So without funding the trust, it's simply a document, it's an empty shell. In order to transfer property into the trust, oftentimes you have to retitle it into the name of the trust. So if it's for instance, an investment account, you'll open an investment account in the name of the trust and transfer property in. If it's property, real estate, you'll want to retitle it to the trust. And what assets go into the trust is really dependent on someone's individual situation. I don't think most people don't put all assets into a trust, only some assets. But you don't necessarily lose control when you put assets into a trust. The revocable living trust you control during your lifetime. It can be changed during your lifetime. It only becomes irrevocable at death. So putting things into a trust does not necessarily mean that you lose control over that asset. And you can buy and sell within the trust. It's just the trust buying and selling. So the thing to watch out for is that trusts are subject to different tax rates than individual income tax rates. So you want to be careful when putting things into a trust that could trigger taxes at a higher rate. So let's talk about the advantages and disadvantages of probate. Probate is a legal process overseeing the administration of your estate. Advantages include that they are protecting the decedent by the person who passed by ensuring their wishes are carried out. You're protecting heirs because they know they're going to be receiving the property orderly and with clear title. But you're also protecting creditors of the estate because when you probate an estate, a notice to creditors will be sent out in order to ensure that the debts are paid, and those debts are paid before the final distribution of assets are paid to the heirs. Disadvantages include that it's a time delay. It takes time to go through probate court. There are multiple filings. You have to typically hire someone to represent you in probate court. So there's a cost to that, having an attorney. And there's a loss of privacy. So what a probate is a public record. So if you search, you can find all kinds of people's wills. And some of them are very interesting to read. For example, Elvis Presley's will. You can find all kinds of celebrities' wills because probate is a public process. So let's talk about estate taxes. I think that everyone is concerned about this, and rightfully so. So it's commonly referred to as death tax. The current exclusion, the amount that you can pass without paying estate tax, is $11.58 million per person. What does that mean? A married couple with an estate valued at $20 million can pass 100% of those assets without paying an estate tax. However, if you have a $24 million estate, anything above that exemption amount of $23.16 million is subject to 40% tax. That's the current estate tax rate. So there is nothing permanent about the estate tax. We've used permanency in the past. The current exemption amounts, the 11.58%, is due to sunset in 2025. At that time, estate tax rates are going to revert back to the 2018 $5.4 million rate indexed for inflation. That's a much lower exemption amount. Can it go lower? Yes. I think a lot of you probably remember when there was talk of lowering the exemption amount to $1 million. And a lot of people went in and did a lot of gifting at that time to get stuff out of their estate, so that they would be below that exemption amount. And there are several ways we can transfer property during life to remove it from the estate without giving up control, without giving up the income. So know that Washington's starved for revenue right now. You've seen all of the, right now we have historically low income tax. We've got historically high estate tax exemptions, but we also have been pumping money in to boost the economy up because of the virus. If you've heard about the Fed and what they've been doing to, I'm sure everyone's heard about the additional unemployment payments. At some point, America's going to have to pay the piper. And I think that what we will see is much higher tax rates and probably a much lower exclusion rate. And that is one of the reasons that landowners can sometimes have a taxable estate, whether or not you're rolling in the income on in the operation, simply because land is valued at so much, and we've seen land values increase so much. So you can see there the word portability. What does that mean? It means if I pass away and I have not used any of my $11.58 million deduction exemption amount, my spouse can elect to use it after I'm dead. I don't have to use it before I die. It's portable to my spouse so that my spouse can use the full exemption amount of two people as if we were both alive. The unlimited marital deduction allows an unlimited amount of property to pass to a surviving spouse free from federal estate tax and most state death taxes. So you can see that if you don't know what your taxable estate is, that is something that I would say do now, and do what we call an estate fire drill. What does that mean? That means we go in and say, here is how your assets will pass currently. Here is the taxes that will be due, and identify the assets that you want to use to pay those. So I have a couple more questions here. One member asked if an estate can be left to a minor. That is where the guardianship clause comes in, and trustees. So I doubt that you would want to leave an estate to a minor. So if you name a guardian and a trustee, a lot of people will put a testamentary trust, that everything goes into trust until the child turns 25 or 35. I think it's better to use lifetime trust, to where the assets flow into the trust, and the trust is there to protect. Remember, a trust is a sort of wrapper of protection around your assets. It protects them from lawsuits. If you got into a car wreck and you had received assets, inherited assets in trust, if you're sued on that car wreck, they cannot attach those trust assets. It insulates them from creditors. If a beneficiary of a trust gets into a credit crunch, and now creditors cannot come after those trust assets, or from divorcing spouses. So I would say there are uses for a trust. What type of trust is going to depend on your particular estate. Your estate plan that is my first brand that I ever did. And like a brand, no two are alike. It should take into consideration your assets, the resources available, consider your personal objectives, and then offer solutions in a tax efficient manner. One of the things that I am going to share another presentation here that we had done some time ago. Let me go into, let me pull this down. Someone asked about family limited partnerships and where these might be useful. One is that they are useful for gifting. A family limited partnership or LLC allows you to create voting and non-voting shares. And that's typically one of the barriers to estate planning, is that we have clients who come to us who don't want to give up control. In any transaction, there are three components: equity, income, and control. And a lot of times you don't actually have to give up control. So you would create an FLP, family limited partnership, or limited liability corporation, and have voting and non-voting interest. Those interests are typically valued at a discount because there's a lack of control. The limited partners can't make any of the decisions until you have passed and you pass on your general partnership shares, and a lack of marketability. If I own limited partnership shares with my siblings, and I want to go out on and sell my shares, it's unlikely that anyone is going to want to buy my shares because they're not going to want to be in business with my siblings. You can maximize the lifetime gift tax exemption. Remember, we said you can give away $11.58 million to get that out of your estate in order to bring your estate down to below the exclusion amount. So let's see how that would work. This is an example. A rancher transfers the business to an entity such as an FLP or an LLC, and then gives discounted shares to the heirs. They maintain their general partnership shares, only gift the limited partnership shares until death. If you had, let's say, a $5 million estate and you received a discounted shares of 30%, so you've now gifted 5 million minus 1.5 million out of your estate and used up less of your exemption amount by 1.5 million. So that is something that I think that it works very well when you have multiple heirs. It works really well for a closely held business. Once it is in the limited partnership or the family, the LLC, it now passes via that operating agreement, that document. The only thing that would pass typically is be included in the estate or the general partnership or any retained limited partnership interest. Before I open it up to more questions, I wanted to also to show you, this is something that has been on everyone's minds, and that is the election and the effects on the market. So here's what we do know. Markets have performed well under both political parties. You're better off staying fully invested versus only investing during one party, and predictions tend to be wrong. Market returns are an outcome of many, many variables. You're investing, remember, in a company. You're not investing in the government. Government involvement, you can see here, is much like a car on rails. The car can only move so far as the rails are what determines where the car ultimately goes. So this shows market participation is about participating and staying fully invested versus in and out. You can see here that during all of these political cycles, whether it was a Republican or a Democrat in office, the markets prevailed. Here is the effects of compounding. If you were to invest $1 in 1940 in the market, and you stayed fully invested through all political parties, whether either party was in office, you would have ended with 4,361. However, let's say you only invested during times of Democratic rule or Republican rule, your $1 would have grown to $172 and $25 respectively. What does this tell us? It tells us staying invested and allowing our money to grow leads to long-term success in the markets. Oops, sorry about that. So there is no conclusion as to which party actually produces better returns. As you can see here, under all of these presidents, whether they were Democrats or Republicans in office, the markets performed positively. Here, we had Hoover in 29 to 33. So that was, more of an anomaly. But what you can see here is that both parties produce positive results. Election cycles, regardless of the outcome, the returns tend to be similar to any other year. This is the return percent for 6 months prior to November. Average annual run to an election, 3.42. Average all November, 6 months prior to November, 3.59. This is the average, the returns for years surrounding election. Average election year return, 10.38. Subsequent year, 9.54. And long-term is 12.69. So really, there's no evidence that the 6 months leading up to an election are any different than any other year. So both, again, produce positive returns. Well-positioned companies are going to create value regardless of who sits in the White House. The overwhelming majority of what happens is dependent on the consumer. It's depending on us going out and buying. Our objective really should be is how we participate in this private consumption part of the economy versus this is the 21% of federal, state, and local government spending. The other thing that's not new is it always seems that people say it's just so ugly out there. Both parties are at it. We've never seen this in history. Not true. If you can see here, these are announcements printed in the press. Thomas Jefferson and John Adams both came out against the press, and you could say that they were the first ones to say fake news. We had the deadly duel between Alexander Hamilton, who was former Secretary of the Treasury, and the Vice President Burr, where Burr shot Hamilton. This is everything, much of what you're hearing today, the vitriol, has been said before. This is not the first mudslinging partisan election. Okay, so let's talk about the experts that are predicting what is going to happen to the markets depending on who gets in. Remember where we were in 2016. We had the Brexit vote. In October, Clinton held a 14-point lead, and everyone said the markets were going to crash if Trump wins. Well, we've seen what the markets have done. I'm not advocating for one party or the other. What I'm saying is we have been in these similar situations before, and all the experts who predicted the end of the world were wrong. It was not the end of the world. Here is the hypothetical probability that you will make the right decision on guessing the election outcome, the market reaction to the outcome, getting out at the right time, and getting back in at the right time. Remember, if you are trying to predict if you're going to get out at the market high and get back in at its low, you have approximately a 6.25 potential of getting all of those factors right. That means you have a 93% chance that you will get it wrong. So I wanted to thank you, and if you have questions, I think we saw a few come in there, and I know that Gabby, you were going to lead those to me.
Yes, I just wanted to make it easier on you. So the first question we have come through, it says, do you have any suggestions about how to handle or consolidate an undivided interest in a piece of land, and in particular when owners don't know each other?
How to, you had a lot there. How to consolidate an undivided interest.
When they don't know each other.
Yeah, I would have to I think we could put it into all interest into an entity. I think that Not sure if we could get I'll look into that one. I don't want to give any wrong advice, so I will follow up on that one.
Okay, that's fine. Yeah, and if this attendee is still on, if you need to provide further follow up, you can always send it to us, and we can send it to Jackie also.
And then I will also, I'm going to pull this up again, and there's my contact information.
Perfect. Yeah, so that'll work. If they have other things they want to add, they can just send it through there. Okay, so from Tom, he's asking, what are the financial conditions to incur an estate tax?
That would be an estate value if you are single of over 11.58 million currently. Double that if you're married. Again, however, I would say that that is current. That exemption amount is actually due to sunset in 2025. I would be surprised if we don't see it sunset quicker than that. I think that, again, Washington's going to have to raise revenue. And currently with the exemption amount, there's only a handful of estates that are needing to pay estate taxes. So that's what you would need to have a taxable estate. However, I think that if you have an estate anywhere over the 5 million mark, which is what we will sunset back to, then you should probably start planning now. Right now, we can use the 11.58 million to pass assets up to that amount of state tax free. If you don't use it, you lose it once the exemption amount goes down. So take advantage of these high exemption amounts now to get your estate down below the exemption.
Okay. And then we have another question from Juan. What is the current amount of unified tax credit? I want to make gifts during my lifetime.
The estate tax and gift tax exemption amounts are married. So that would be the same amount that you can gift using your lifetime gift amount. Now, if you want to make annual gifts, and these are smaller gifts, you can gift up to $15,000 per beneficiary per year. And again, that is per couple. So a married couple could actually, if they wanted to gift grandchildren, and let's say they have 5 grandchildren, they can give their grandchildren $30,000 each annually without having to incur a gift tax.
All right. And then this is the last one on here. So if anyone else has any other questions, feel free to go ahead and put them in the chat or in the Q&A just so we can keep on track. But Robert asked, in the inventory for probate, how valuable is the depreciation on equipment in determining the amount declared?
How valuable is it? I would say that you're going to use a fair market value as of the date of death. So if I have a tractor that has depreciated fully, that value is going to be that much lower for the probate inventory, for the inventory of the estate.
All right. And anyone else, if y'all have them, just go ahead and put your questions in there. We did have someone ask earlier if the slides would be available. So this whole session is recorded live, so you'll be able to get it that way. And then we can also ask Jackie if she's comfortable with sharing the slides. We can also send that out later. Sure. Or make that available on the website too. So just so y'all know about that. And anything else that was asked throughout here, it was just mostly feedback. Everyone really enjoyed the presentation thus far. So,
well, I'm glad. This is such a passionate topic for all of us in our firm. Like I said, if you haven't had that sort of estate fire drill done to see how it would work, if you're working with somebody currently, ask for it. If you're not, that is what our firm does. We will assist you in kind of determining if it's set up to, carry out your wishes, if it's taking full advantage of all of the tax benefits and exclusion amounts and transfers that are available to us now.
Great. Yeah, and I haven't seen any other questions come through. So I guess if anyone has questions that we end up missing, just You can send those to Jackie or send those to us directly, and we'll field those after the presentation. But many people have sent their thanks to you through the chat and the question answer as well. And I just want to encourage people, as Jackie said, she has been a resource for us for a while. So if you have other questions or want to get set up with a consultant, I'm sure she'd be a good fit for that, or point you in the right direction if you're not sure. So we want to make sure to thank her for her time today. And is there anything else you want to add at the end, Jackie?
No, just thank you. And I hope that we all get to see each other again soon in person. I think that this virus is going to be with us, and these are indeed strange times, but I think that the markets will persevere, and so will we. I encourage everyone to make sure that, you know, you have your ducks in a row, because what this has definitely shown us is that we are never sure what the future will bring. And so thank you all, and I hope to hear from you if you have questions, concerns. That's what we're here for. Use us as a resource.
All right, perfect. Well, thank you all so much, and we will send this recording link out as soon as it's available.
Thank you.
All.
Bye.